Hey folks, thanks for watching my monologues. In case you haven't heard, I'm told there's an election coming up pretty soon. In some areas, there's a lot of violence and civil unrest. If you're in the market for personal protection for yourself or your family, I'd encourage you to visit Guns Etc. Guns Etc. is 10,200 square feet and they have product. And they're getting new product all the time. They'll work with you to get the exact type of protection that fits your needs. Stop by their store in Mesa or visit gunsetcetera.com where you'll have access to over $400 million worth of firearms and accessories. And if you like my monologues, please subscribe to 960 The Patriot's YouTube channel. Welcome back and happy September 22nd, 2020. It was about a year ago we engaged in a tour of the Bill of Rights. We did an amendment a day, and within certain amendments a little more. As you know, the First Amendment has both religion and speech. The point of our doing that was because enough confusion about the Constitution existed and exists, nay, reigns. And it was birthed by the courts, primarily the Supreme Court. Confusion is a good thing for and to the left. It moves across our entire polity. The point is to fuddle them, old Screwtape reminds his nephew Wormwood. Confusion, though, is not good for any kind of polity that claims to respect the law or have a respect for the law. Confusion is not good for any kind of polity that claims to have a constitution when confusion honeycombs the Constitution, not because the document is unclear, but because courts have saturated it with opacity and doubt. When, as I said yesterday, Supreme Court dicta that gives judges and justices free rein to bring about any conclusion they wish, you don't have self-government or rule of law or anything like something that claims to be a constitution. You have rule by an appointed Politburo, and you have confusion or anarchy. Anarchy in the law because there becomes no settled law. To wit, and for example, some years ago, Professor Robert Bork wrote this just about the religion clauses of the First Amendment. Quote, where religion is concerned, for example, a state may lend parochial school children geography textbooks that contain maps of the United States, but may not lend them maps of the United States for use in geography class. A state may lend parochial school children textbooks on American colonial history, but not a film about George Washington. A state may pay for diagnostic services conducted in a parochial school, but therapeutic services must be provided in a different building. At this moment, he continued, the most prominent issue involving the religion clauses of the First Amendment stems from the decision in Engel versus Vitale and subsequent cases prohibiting prayer, Bible reading, or even a moment of silence in public schools. In addition to declaring that these are all violations of the First Amendment, the court has held unconstitutional even school practices that are neutral as among different religions on the grounds that under the First Amendment, religion may not be preferred to irreligion. Since the vast majority of Americans are believers, these holdings are fiercely resented by most of them as attempts to impose secularism on their children, and school prayer remains a simmering political issue. Close quote. All of this is why Antonin Scalia could write that the Supreme Court had mistaken a culture camp for a fit of spite. Culture camp, there's that word again, culture war. We're in one, and we've been at it and in one for a long time. As I pointed out yesterday, only recently have we woken up to it and joined it. Where left-wing desiderata is voted down and refused by the electorate, there the courts are to help install the wishes. When common sense desiderata are voted in on everything from speech and religion to race relations to health and family and welfare and immigration law, there the courts are to help find rationales to undo them. You take a phrase from the Supreme Court like this. We read it yesterday. At the heart of, quote, at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life, close quote. You take a phrase like that, court dicta, and you can reach any subjective conclusion you like. When you have justices speak of penumbras formed by emanations to find rights in the Constitution never contemplated by its authors, you can reach any subjective conclusion you like, or you can summon 5 people to agree with. So now the funny thing comes. We're told by those who routinely give us these decisions that we originalists are the ones who are radical or departing from mainstream judicial reasoning, that we are judicial or legal extremists. If radical or extreme is what they want, I can show them some. I'm reminded of C.S. Lewis's lesson that if you're on the wrong road, progress means doing an about turn and walking back to the right road. And in that case, the man who turns back soonest is the most progressive man. Now, I ask you to just think about how very far the set point has moved, what we've become accustomed to, what we have become used to, because it may be described as many things, but constitutionalism it is not. As Chief Justice John Marshall put it early on, let us not forget it is a constitution we are expounding, he said. Expounding, meaning and coming from the word explaining. That is the court's job in judicial review, explaining, not changing, not altering, not revising. Think of what we take for granted, except just assume in things important, legal and illegal and judicial. I'll give you a tough one. How many times have you heard the phrase freedom of expression? Guess what? It's not in the First Amendment. But it's a phrase adopted by the courts to give legal countenance and protection to all manner of things our Constitution's authors, as much as our present-day constitutional majorities, would never have approved. Professor Walter Burns, whom is the best guide on these matters I respect, put it this way some years ago in the context of flag burning, held constitutional as a matter of expression, and of things like endowing the art of Robert Mapplethorpe. Burns wrote, quote, according to the unabridged Oxford English Dictionary, expression originally meant the act of pressing or squeezing out, hence to expel or get rid of by force. Just so, in one of his photographs, Mapplethorpe shows one man artfully urinating into the mouth of another, expelling urine by force, so to speak, or so to express. In another of his photographs, he also shows a bullwhip thrust handle first into one of a man's bodily cavities. Burns goes on, in fact, of course, the First Amendment protects not freedom of expression, but freedom of speech. Congress shall make no law, it reads, abridging the freedom of speech. But it might be asked, what is expression if not one of the forms of speech? Indeed, to refer again to the dictionary, the word soon acquired the meaning familiar to us, the utterance of feelings. Besides, in our postmodernist world, speech and expression are easily confused and just as easily identified. Close quote. In other words, the Constitution's framers, they weren't inexperienced in language. In fact, they were pretty uniquely gifted in the English language. If they meant expression, they would have written expression into the First Amendment. They didn't. They wrote the word speech. Put it this way, if they meant expression, why would they write in the First Amendment that it forbids Congress from, quote, abridging the freedom of speech or of the press or of the people peaceably to assemble and to petition the government for a redress of grievances, close quote. Why, in other words, if they meant expression, put in speech and press, never mind assembly and protesting the government? Wouldn't expression just globally be all of that and cover all of that? The framers thought words meant something, and they specified what they meant in the First Amendment. The court changed it, which is how you get expression, which covers things like flag burning by any other standard, not truly or actually speech. We actually understand this distinction very clearly today, especially, don't we? Think the difference between riots and peaceful protests. So now that I think about it, do you think we will someday, if we remain on this present course, see a judicial scholar or judge say rioting is indeed protected expression? Heck, flag burning is, and fires, the cause of the burning, are one of the chief distinguishing characteristics between riots and peaceful protests, are they not? So why not? We already have books justifying looting, don't we? The slope is rather well greased, I'd say, wouldn't you? You want extremism and radicalism? I'll give you some more. We went through this recently, but the Supreme Court backed us into relativism in the First Amendment and our entire constitutional order a long time ago. It's just assumed now, accepted, adopted, that Nazi speech should be protected, as should communist. Why? Back, if I may, to Walter Burns. Quoting him, "Just as beauty is in the eye of the beholder, so truth is relative, a proposition that found its way into our law through the good offices of two of our most famous 20th century Supreme Court justices, Oliver Wendell Holmes and Hugo Black. If, said Holmes in 1925, quote, the beliefs expressed in a proletarian dictatorship are destined to be accepted by the dominant forces of the community, the only meaning of free speech is that they should be given their chance and have their way." Close quote. You want it again? If the beliefs expressed in proletarian dictatorship are destined to be accepted by the dominant forces in the community, the only meaning of free speech is that they should be given their chance and have their way. So too Black in 1961, writing, quote, "Education and contrary argument may provide an adequate defense against communist and fascist speech, but if that remedy is not sufficient, the only meaning of free speech must be that the revolutionary ideas will be allowed to prevail." The only meaning of free speech must be that revolutionary ideas will be allowed to prevail. But is that right? Is that what our Constitution was meant for and defends? Article 4 of the Constitution guarantees to the states a republican form of government. It goes further, saying the federal government shall protect each of the states against invasion on that guarantee. So to borrow from George Will, quote, liberals quote Oliver Wendell Holmes's maxim that, quote, the best test of truth is the power of the thought to get itself accepted in the competition of the marketplace. The best test of truth, Holmes wrote, is the power of the thought to get itself accepted in the competition of the marketplace. Liberalism is a philosophy that yields the essential task of philosophy, distinguishing truth from error, to the marketplace, which measures preferences and popularity, not truth. Liberals say all ideas have an equal right to compete in the market, but the right to compete must imply the right to win. Liberals seem to believe that all speech, any clash between any ideas, necessarily contributes to the political ends the First Amendment is supposed to serve. But they must believe that the amendment was not intended to promote particular political ends, that there is no connection between the rationale for free speech and the particular purposes of Republican government, right? A wiser theory is Walter Burns's, cited above, who argues that the First Amendment is part of a political document. There are political purposes for protecting speech, and some speech is simply incompatible with those purposes. The purpose of the Constitution, he argues, is to establish a government faithful to the self-evident truths of the Declaration of Independence. Oliver Wendell Holmes, said the Constitution was written for people of fundamentally differing views. That would be an absurd idea about any constitutional community, and is especially absurd about this one. The founders thought rational persons could hardly avoid agreeing about self-evident fundamentals. The founders believed in freedom for all speech that does not injure the health of the self-evidently proper kind of polity, a republic. So the distinction between liberty and license, between permissible and prescribable speech, is implicit in the Constitution's very purpose. Hence, restraint can be based on the substance as well as the time, place, and manner of speech. Burns argues it is bizarre to say that the Constitution, a document designed to promote particular political ends, asserts the equality of ideas. How could it? There is no such thing as an amoral constitution, neutral regarding all possible political outcomes. So to accept that, given all this, given the guarantees of a Republican form of government, today's First Amendment jurisprudence must conclude it is worse to punish the advocacy of Stalinism and Hitlerism than it is to be ruled by Stalin or Hitler. What else could one conclude from a court that accepts the notion that if the beliefs expressed in proletarian dictatorship are destined to be accepted by the dominant forces of the community, the only meaning of free speech is that they should be given their chance and have their way? So yes, we've wandered a very far distance from true original intent, I should say, wouldn't you? Now, to argue all this, as I have, as George Will has, as Walter Burns has, would truly be radical. Indeed, especially so if you realize the word radical comes from the Latin word radicalis, meaning having roots, meaning going back to origins. Call me that kind of originalist. I think James Madison would. I'm Seth Leibson. We'll be right back.